right. We are back. We are.
Dude, again, for 20-something shows, I never heard the music. I like it.
Thank you.
It's pretty cool.
Thank you. Thank you. Thank you.
All right. Well, as you are all aware out there in TV land, my name's Paul Reed, the Ed McMahon to my Johnny Carson, Jason Crawford. We're here for another edition of Live Feed Reed. It's Friday, obviously 1 o'clock. I'm appearing from Brandon. Jason's appearing from Tallahassee. Yep. It is filthy hot, but we're just going to get past that. Our boy Pat, who does our internet stuff, the computer SEO, I don't know, things that matter to Google and how you get on first page and all this other stuff that literally I know little about. He likes us to talk about our real world cases and things that we've done. And so Jason and I, when Jason was going through the internet, he trolls the internet way too much. Yeah. But that's a whole different issue. He sends me things all the time. I delete 90% of them, but this one was pretty funny. And I said, you know what? And he says, hey, can this be a case? And I said, we can talk about that because we've handled multiple cases like this. And so the title today is, Jason, what is it? Waiver.
Injury waivers and epic fails. What happens?
Oh, there you go. Injury waivers and epic fails. Now, I know you people in TV land have seen millions of epic fails. So Jason just chose one that was a little funny, brought a little humor to the set, and I don't think the child was injured. Yeah, but it's pretty funny. Jason, let's roll that to start the program.
Although the kid at the end is screaming, "I broke my arm! I broke my..." So that was why I was concerned.
Well, then, hey, what do I know? I just kind of glanced through it.
We'll figure it out. Here we go. Let's roll it.
Yeah.
Oh my word.
Hold on.
Over and over.
Oh my.
Here it is.
Oh!
I broke my hand.
Anyway, all right.
Yeah.
All right. Yeah. So those the moral of the story, though, is why these waivers, they're called exculpatory clauses, are valid, is because people do get hurt.
Yeah.
All right. People get hurt at the bouncy ball, the trampoline, and there are, believe it or not, many, many injuries at fitness centers.
Oh, yeah, that's a good point.
Yeah, so we had a case, let me see, it was filed in 2019, where Toby had gone to LA Fitness, and at some point during this her workout and afterwards, she was injured in the parking lot, actually.
Oh, wow.
And so we filed suit, and at some point the defendant, which was LA Fitness, and they're all more or less similar, filed what's called a motion for summary judgment, Jason. And I don't know if we've talked about this, but I'll go briefly into what a motion for summary judgment is. So you file a lawsuit, both sides do discovery, interrogatories, depositions, things of that nature.
Okay.
And when that's done, if one side, in this case the defendant, feels that they should be dismissed as a matter of law, meaning there are no facts that a jury can decide for the plaintiff, and that this case should be dismissed. That's called a motion for summary judgment. Now, they're not easy. The courts don't like them. But if you're right, and on either side, the plaintiffs can file them typically like on a rear end crash. Yeah. You know, you rear-ended me, I didn't do anything wrong. We file a motion for summary judgment that there's no issue for a jury to determine that I did anything wrong, and therefore, you know, we get past that question on the verdict.
Right.
But on this one, if you scroll down,
where to?
It says LA Fitness is alleging that they have one of these exculpatory clauses. So go down to where it says undisputed material facts.
Okay.
All right, right there. So basically, they're saying that she was at the LA Fitness as a member, that as a member, she signed the membership agreement, and that she was injured, you know, in the course and scope of her being at and using the equipment at LA Fitness. That's the gist of it.
Right.
I'm not going to scroll down to the release and waiver of liability that was attached,
Mm-hmm.
and I'm not going to go into it. But boy, if you read this, it says everything from if you're injured in the shower, if you're injured in the hot tub, if you're
Mm-hmm.
injured in the sauna, if you're injured working out, if you suffer a heart attack, if you suffer a stroke, if you have heat stress, if you tear muscles, ligaments, bones, you name it.
Yeah.
If you're injured in any way, shape, or form, when you walk into that establishment, you can't sue us.
Wow. Yeah. Okay. Yeah.
Okay. So that's and then it goes into the standard and this, that, and the other.
Okay.
All right. So that was we received that. And you don't like receiving it, okay? We just received another one. But we'll respond accordingly to that. But let's just stick with the case here today.
Okay.
So we file our memorandum in opposition,
Okay.
meaning Judge, why, and you can pull that one up, take your time. Judge, why should you not grant a motion for summary judgment on this case?
Mm-hmm.
Basically, just like it says, plaintiff's memorandum in opposition to defendant's motion for summary judgment. You see that?
Yeah.
All right. And if you read under the factual background, I said on July 10th, 2018, the plaintiff suffered injuries. And this is what's important. When she stepped in a hole on the sidewalk outside of the front door of LA Fitness, then we attached the photographs of the hole, incorporated them into our motion for summary judgment.
Mm-hmm.
And so at the time of the incident, the plaintiff had exited LA Fitness and was walking towards her car, right?
Okay. Yeah.
So then we talk about the waiver, and I go, if you look at 1, 2, 3, and I say, if you look at it, it says, and you kind of, what do you, highlight it or italicize it, in consideration of a member being permitted to enter any facility of LA Fitness for any purposes, including, but not limited to, on and on and on.
Mm-hmm.
Okay. So I highlighted that their exculpatory clause says that basically once you've entered into the facility, right?
Okay.
And obviously had to read it, try to pick it apart. And then I go down and I talk about it and this, that, and the other. So then just the legal analysis, same thing. You just put that in there on how or when it should be granted. There's cases in this. The judges really don't read any of that. It's pretty clear.
Right.
They know
they're familiar.
There cannot be any material fact that a jury can decide in favor of the non-moving part.
Okay.
You with me?
Yep. Yeah.
So then I go down, so you move on, and it says, go to the conclusion.
Yes, I'm here.
I said, okay, it says to the ordinary person joining the gym and being presented with the contract signed by the plaintiff, which includes an exculpatory clause, one would conclude he or she is waiving the right to recover damages from LA Fitness for injuries sustained while performing those activities, generally referred to as working out.
Mm-hmm. Okay.
That's our position. That, in the ordinary course of someone reading this exculpatory clause, you would interpret it as, yes, when I'm working out or I'm in the sauna or in the hot tub or in the shower or this, that, and the other, when I'm kind of using the facility, I understand, even though, Jason, nobody reads these,
Mm-hmm.
but I understand that if I'm injured, I can't sue you.
Right. So the argument that you're making here is that they had a duty to upkeep the premises, not just the working out portion of it. And so this is an injury sustained outside of the parameters of the member.
Exculpatory clause.
Yes, thank you. Yeah. Okay.
100%.
Okay.
My position was that this injury is not encompassed within the meaning, the language of the clause.
I think that's a fair approach, because it's different.
Well, guess what? It's the only approach I have.
Yeah. Well, I mean, it doesn't matter what I think either. It's the judge. So.
Make no mistake. It don't matter what I think. It doesn't matter what the defense attorney thinks.
Yeah.
You know what matters?
What the judge says.
Oh, believe that.
Yeah.
And I got news for you, people out there in TV land. There are judges, and there are judges sitting there in the courts throughout the land
Mm-hmm.
that if they don't like your case, so to speak, or they're conservative, or they're liberal, or they're this, or they're that. It don't matter what I think. It doesn't matter what you think. They're just going to rule what they think. And
Wow.
we see that all the time.
Yeah.
We see it all the time
Mm.
in the newspapers and so forth. So make no mistake, I think I'm kind of saying something that makes that everyone agrees. Judges have power.
Yeah, they do. They do.
And in a plaintiff's personal injury case, this judge could kick us to the curb, and then you got to appeal. Those judges, the discretion of the trial judge is, abuse of discretion. It's appealing, all appeal. Well, 10-15% may win an appeal. And that's where I always tell you, I read my Florida Law Weeklies every week. They're full of, you lose, thanks for coming.
You know what it feels like when you have to appeal? This.
What? That was beautiful.
Sorry.
Yeah, and believe me, I have been on that side like that little boy. That is exactly what it feels like. That was hilarious. Okay, so that's this case. It's real live. It was 2019. Toby was injured, broke her ankle in a basically a hole in the sidewalk, about 3 or 4 steps from the building, right before the step down to the parking lot. They file a motion for summary judgment saying this exculpatory clause bars their cause of action. I find a memorandum of law saying no, it doesn't. So, okay, ready? Drum roll.
Yeah.
I don't know if you have
one. Yeah, I think I do.
Drum roll.
Hey, where did it go? I've got rim shot. Oh, wait. No, I don't see drum roll. Sad day.
Well, we'll add that to your repertoire next time.
Yeah.
So, Jason, what happens?
I don't know. I think the judge sided with LA Fitness and just said it's all encompassing for any interaction that they have with the member, period. That's going to be what I think, because I'm maybe I'm a realist or a pessimist. I don't know.
Oh, you're preaching to the choir. Well, again, drum roll.
All right.
We settled the case. We settled the case 7 days later.
Oh, okay.
Yeah, neither side wanted to risk losing.
That's good. That's good.
Yeah. Now understand. That's not unusual.
Okay.
Because here's what happens when in a case like this.
That means they thought your case had enough teeth for them to.
Well, that exactly. Well, and think about it. Personal injury cases, defense plaintiffs, it's just like playing poker.
Mm-hmm.
You've got a hand, they've got a hand, and you have good cards in your hand, bad cards in your hand. They have good cards in their hand, you have bad cards. And so they file this. And so typically somebody's going to lose.
Yeah.
Right?
Yeah.
Now, if the plaintiff loses, she gets nothing.
Mm-hmm.
Forget the appeals, all that. Because like I said, that's like that little boy getting popped.
Yeah, understood.
If the defense lose, now they're going to have to pay more money because their motion for summary judgment isn't granted, and we have a fractured ankle, and it gets to go to a jury, and clearly the judge has held that you're going to have to pay something because when you have broken bones, the jury is going to award you money.
Okay. Yeah.
I say that. The jury could always say, look, there was a pothole in the sidewalk. You should have seen it. You get nothing. There were other issues that could have gone wrong, but either way,
yeah,
the LA Fitness didn't get out for nothing without risking a trial.
Yeah. Right.
This is not unusual. And so what both sides do is, LA Fitness, I'm going to give you less than what you think the case is worth. The plaintiff, well, we're going to get more than what you think the case is worth because you think it's a zero.
Mm-hmm.
And somehow you resolve the case because you don't know what the judge is going to do. So LA Fitness gave more money than they wanted to. The plaintiff, Toby, accepted less money than she wanted.
Yeah.
But you didn't leave it up to a judge to decide which one he is going to lose.
Which one gets zero? Yeah.
Well, which one gets zero or might pay more than what you could settle the case for without risking a jury trial, because jury trials are risky.
Yeah.
It's just that simple.
Yeah.
And everybody knows.
Yes.
I've won cases I thought I should lose cases you think you should win. Dude, if you could predict that with a crystal ball, you would be the richest man on the face of this earth, past Bill Gates or who. I mean, if you could predict what a jury's going to do, you'd have more money than there is money. But either way, so that's what happened.
All right.
We don't know who was right. I personally think, obviously, that this was not encompassed in the waiver. It was a defect in the parking lot, so to speak, and had nothing to do with her working out activities at LA Fitness.
Yeah.
But again, I don't. Let me see. Let me see.
And they're
I can
responsible for.
hold on one second.
Okay.
Let me look and see who the judge was. I think we would have won. Judge Tibbles was pretty fair. I don't think he would have granted it. I believe he's on a court of appeals now, or at least he was. This was a long time ago. But Judge Tibbles was a good judge, and if he's still there, is a good judge. I don't know that he would have granted it. But again, you never know.
Yeah, I think that's.
If if some other names had popped up, I would have said we lose.
It's a part of knowing, what you're up against too. Whenever you're like, what judge you're sitting in front of does also matter when you're looking at settling or negotiating.
Oh, make no mistake.
Yeah.
But again, this Judge Tibble, it could have still gone either way. But I think he would have leaned more, let the jury decide what this case is worth.
Yeah.
But that having been said, all right. Well, so that's it.
That's what happens when injury waivers meet epic fails.
Yeah, exactly.
Yeah.
All right. Well, let's see. It's the heat wave should be
it's
back
crazy.
To 90 in the low 90s. When you get to wake up Sunday, make sure you hit church. Give Jesus his 1 hour a day. Ain't gonna kill you. Say thank you for all that you've done, all the many blessings, and whatever other prayers you may have. You'd be surprised. He may not answer them tomorrow, but he may answer them in his time. Jason's going to be down at this a final homeschool seminar workshop down in West Palm Beach, and Jason is busting the old bizzalls, trying to get these people to basically see things his way.
Well, I mean,
or hit the highway.
Well, it's not exactly
behind you. Jason's been past the hammer of homeschool education, and so he's taken the mantle, and I don't think they could have asked for a better person to do so, because actually, like he says, we care about our clients. We do. He cares about his kids, and when I say his kids, homeschool kids at all, and so that's good. Passionate.
Thank you, Paul.
And when you're passionate about something, usually you get things done. So there's a little plug for Ed McMahon.
Thank you, Paul. That actually gave me chill bumps. I appreciate that.
Give us some of that cool music and take us out.
You got it.
Reed and Reed, it's like having a lawyer in the family.